Good evening, everyone. A very warm welcome to today's webinar organized by the Just Anima. For those joining us for the first time, the Just Anima is a legal platform dedicated to creating legal awareness, encouraging legal learning, and providing a space for meaningful discussions on law and contemporary legal issues through its various initiatives and programs. The JUST Anima aims to connect students, legal professionals, and individuals with valuable legal knowledge and opportunities. Before we begin, I would like to request all the participants to put their questions or queries in the chat box during the session. We will take up the questions towards the end of the webinar during the Q&A session. It is my pleasure to introduce our esteemed guest, Mr. Mohammad Subur, Associate Counsel at the Indian Institute of Arbitration and Mediation, IIAM. Sir is an Indian qualified legal professional with a professional focus on arbitration and dispute resolution. He has undertaken specialized training in commercial arbitration at the Indian Institute of Arbitration and Mediation, IIAM, and is an IIAM impaneled arbitrator. He has also served as a tribunal secretary in multiple arbitrations, assisting arbitral tribunals with procedural orders, legal research, and award preparation and case administration. In addition, he is impaneled as assisting counsel at the Supreme Court Legal Services Committee, SCLSC, Supreme Court of India, and has contributed to several articles and research publications on arbitration and dispute resolution. We are truly honored to have him with us today and look forward to an insightful and engaging session. Sir, a very warm welcome to the Just Anima.
Thank you so much, Ramsha. I hope I'm properly audible to all of you, audible and visible.
Yes, sir.
Perfect. So thank you so much for inviting me for this webinar, and thank you so much for such a wonderful introduction. So before we proceed, would it be possible for all of you to just turn on your video cameras, because it's actually better if you talk to a person rather than talking to thumbnails that are there on the screen. If it's possible for you, then it's perfectly fine. And also, I'll be sharing the screen. So can you give me the access to share the screen?
Yeah, sure.
In the meanwhile, may I know the audience, is it a mix of law students and professionals, or is it purely law students only? So that I can tailor make my session according to that. I think the screen would be visible, right? Law students, perfect. So mostly we have law students here in this session. Oh, okay, so before we proceed ahead with the session, may I know, just having a rough idea, if all of you are aware about what actually arbitration is or how it operates? If any one of you could just unmute yourself and answer this question.
So basically, it's outside settlement
Okay.
in order to resolve the dispute between the parties, and it is governed by the Statutory Act of 1996.
Yes, that is right. Anyone want to add anything to this?
Sir, basically, arbitration is all about where any foreign party is being indulged with the Indian party related to any commercial or transaction based or economic based such type of transaction or business regarding. So, arbitration includes the type of dispute settlement between parties which happens outside the court, and neutral dispatch has been provided for the resolving of the issue between both the parties, and later when the award has been passed between both the parties, then it has been sent to the arbitration tribunal so that it can be resolved.
So that's a very comprehensive definition. So adding on to this and proceeding ahead with this, first we'll cover the basics of the arbitration, what it actually is, and the basic understanding of the subject. And later on, the second part of it, we'll move on towards the opportunities that actually are there in the space of arbitration, right? We'll start off with the overview of the arbitration and how it operates in India. So first thing is that what is ADR? So since few of you have answered that arbitration is a mode of dispute resolution mechanism under the realm of Indian judiciary, right? So moving on, there are different forms of ADR, right? So majorly there are three different forms of ADR. So ADR is the alternative dispute resolution, under which primarily three major parts are there. First one is your arbitration, second is your mediation, and the third one is your negotiation, right? So first we are going to cover the difference between all the three of them. So, as we discussed, and as some of you have answered the question, that arbitration is a form of dispute resolution wherein a third party is involved who adjudicates the disputes between the parties, right? So, in a layman's language, if I explain it in very simple terms, arbitration is basically where a neutral third party is involved with the consent of both the parties, who acts as an arbitrator and adjudicates the dispute and ultimately passes an award. And that award is akin to a judgment passed by the court, right? So, broadly speaking, the process of arbitration entails the process of litigation in some sense. Why? Because again, instead of a judge, a third party who's called as the arbitrator, he is involved to adjudicate the dispute between the parties, and that arbitrator is ultimately the master of the dispute. So all the pleadings, the arguments, evidence, everything is led before that particular arbitrator, or in case if there are multiple arbitrators, then it's called a tribunal, an arbitration tribunal. So everything is led before the tribunal or the arbitrator, who ultimately adjudicates and justifies the passing of the award, and ultimately gives a very well reasoned award. And that award is a very similar to decree of the court, and it can be executed in the similar manner just as a judgment which is passed by the court. So broadly speaking, this is the process or the basics of the arbitration. Now, how do we distinguish it with respect to another form of ADR, that is mediation? If you see in mediation, often people confuse it with negotiation. So there's a very fine distinction between the mediation and the negotiation process. In mediation, the third party is actually the facilitator of the disputes. A neutral third party is appointed who actually facilitates the resolving of the disputes between the parties. So the mediator cannot give suggestions to the party, the mediator cannot adjudicate the disputes between the parties, and unless both the parties explicitly agree, the mediator cannot resolve the disputes between the parties. So, for example, if actually there's a mediation clause in your agreement and one of the parties says that, okay, I'm going to go ahead with the mediation, and the party refuses, then the mediation process cannot be commenced and moved forward with it, right? However, in negotiation, only the two parties, that is the claimant and the respondent, they are involved, and they can do back and forth communication between them to resolve the disputes between them. So negotiation is one of the processes which is actually not very well tailor-made or structured, I would say, compared to mediation. So negotiation is form of a step back towards the mediation. So once the negotiations fail between the parties, then ultimately the parties proceed ahead with the mediation. And if it's a multi-tier dispute resolution clause, for example, if there is a clause which states that first the parties will undergo negotiation, if negotiations fail, then mediation will be followed. If mediation fails, then arbitration would be followed. So this is usually the hierarchy which is taken in different form of dispute resolution clauses which exists in our Indian legal system. Now, Today we'll focus only on the arbitration aspect, right? Moving on, first thing that we'll talk about is which statute actually governs the arbitration. So for India, it's the Arbitration and Conciliation Act of 1996, which talks about the arbitration, which is subdivided into four different parts, right? The first part that we have in Arbitration Act, if you'll see the index of the Arbitration Act, you'll broadly see four different headings or bifurcations within the Arbitration Act. The first thing is the part one that covers about the domestic arbitration. So what do you mean by domestic arbitration? Again, let's fall back to the Arbitration Act. So whenever the seat of arbitration is in India, and the parties that are involved within the dispute also belong to India, the nationality of the parties is Indian, and the seat of arbitration is also Indian, then in those cases, we can say that the arbitration is a domestic arbitration, right? And in domestic arbitration, the Indian laws apply, may it be the substantive law or the procedural law. Only the Indian laws will govern the Indian arbitration or the domestic arbitration. Second part which we have is the ACI, that is the Arbitration Council of India. So this Arbitration Council of India, it was supposed to bring a statutory body which was to come into picture after the 2015 amendment. However, it has been included in the Arbitration Act, but it has not been notified as of now. So once this ACI part is notified or the Arbitration Council of India is actually formed, then a lot of responsibilities with respect to the grading or the accreditation or the ranking of the multiple arbitration institutions that we have in India will fall to the ACI, right? So this part is yet to be notified. The third part that we have in Arbitration Act is the enforcement of foreign awards. So as I recall, one of the participants answered that arbitration is a process of dispute resolution wherein foreign parties are involved or international parties are involved. So this is true to some extent with respect to the international arbitration scenario, right? So whenever the parties have a nationality apart from Indian origin, or if the arbitration is seated outside India, then in those cases you can say that it's an international arbitration, because in those cases only the foreign entities or the foreign nationality parties are involved in the process of arbitration. And the last part is the conciliation part. Again, this is supposed to be replaced by the Arbitration and Mediation Act in the coming years, but let's see when does actually that act gets notified or revamped. So this is the conciliation part. Now, first we'll talk about broadly what are the benefits of arbitration or why people actually choose arbitration. The first thing is that the flexibility that it offers. If you compare it to the traditional court system, it's very much flexible, because in arbitration, what you can do is you can have your own choice of law, which will govern your contract or your dispute. You can have your own sitting. Where do you want to sit and actually conduct the arbitration? You can choose your own venue if you want to sit in a hotel or you want to sit in a conference room, if you want to sit in an institution. It's totally up to you. Next thing is that unlike court systems, so if you might have gone to court for internships or anything, you might have seen that usually a judge listens to a case for maybe 1 minute, 5 minutes, 10 minutes, or at max 15 to 20 minutes, depending on the case that is involved. However, in arbitration, that is not the case. So, whenever you choose an arbitrator, that arbitrator actually gives a fair hearing and equal opportunity to both the parties. And both of the parties can actually present all their disputes and submissions before the arbitrator. So, you have ample amount of time to justify whatever your claim is or whatever your grievance is with respect to the dispute that is placed before that arbitrator. So in that sense, it's very much flexible, the process of arbitration. You can even choose your own arbitrator. For example, if you say that there is a maritime dispute or an aviation dispute between two entities, then those entities or the two parties can specifically choose a person who has the technical knowledge of aircrafts or marine laws. So based on this, based on the nature of the dispute that you're having, if it's a construction dispute, maybe you can choose an engineer who would act as an arbitrator, because he would be having the technical expertise and he would be in a better position to judge actually what are the technicalities involved in the disputes. So in that sense, the flexibility that arbitration offers is actually quite appealing to a lot of people. And because of that, the commercial and the corporate entities choose the process of arbitration. Next is the confidentiality. So when I mention the term confidentiality, it would mean that all the proceedings that are conducted before the arbitrator are confidential in nature. So all the documents, all the pleadings, everything that you submit before the arbitrator is confidential in nature. The other party cannot take that document into a public domain or a public realm until that award is challenged and it comes before the court, and again it comes within the public realm. So until that point of time, the confidentiality arbitration offers is very much necessary. Why? Because if you see, sometimes the disputes which are there between bigger corporations, so if the news of those disputes actually gets divulged outside the arbitration proceeding, it would harm the reputation of the company. Irrespective of the fact whether that company wins or loses the case, it would harm the reputation of the company. So to avoid those things, parties often go for arbitration because it offers the confidentiality. This is another point, right? Next, we have cost efficiency. So, in arbitration, the parties can actually select the fee of the arbitrator with respect to the fourth schedule. The fourth schedule that the Indian arbitration offers, it's a model schedule based on which the parties can fix the fee of the arbitrator. Otherwise, the parties can also tailor make a schedule for their own themselves for the adjudication of the dispute, that this much amount would be paid to the arbitrator. For example, if your claim is around 10 CR, the parties can agree that okay, we'll pay 5 lakh in lump sum to the arbitrator, or 10 lakh or 15 lakh, whatever the amount is, or we can stick to the fourth schedule. Or in case if it's an institutional arbitration, so every institution has its own set of arbitration rules and arbitration fee schedule. So based on that, the fee of the arbitrator can also be decided. Coming to the next point, it is the time efficiency that the arbitration process offers. So prior to the 2015 amendment, so in 2015, a major amendment came into the Arbitration Act, which completely overhauled the entire arbitration system. The major amendment, one of the major importance of this amendment was that prior to the year 2015, the arbitration process was not time bound. So, for example, the process of arbitration could go on for 10 years, 15 years, 20 years. There was no fixed timeline or time limit that within this time the process of arbitration has to be completed. However, this entire thing was changed after the 2015 Amendment Act. After this, what happened? A new section, that is section 29A of your Arbitration Act. If you have the Bear Act, you can open and check it. The 29A was inserted within the Arbitration Act, and this section explicitly states that the entire process of arbitration has to be completed within the duration of 1 year. So this is very much important because often the bigger corporate or the entities or even an individual, whenever they're having an arbitration, if the adjudication of the dispute takes years and years to get finalized, then the fruitfulness of that dispute is not of any use to any of the parties. So to curb this thing or to enhance the efficiency of arbitration, a strict timeline was put on the Arbitration Act. So, presently, as of this point, any arbitration proceeding that is commenced or start has actually to be completed within the duration of 1 year. So that is the position. Coming to the next, we have the finality. So as I told you right at the starting itself, an arbitration award is akin to a decree passed by the court. So whenever an arbitration award is passed, it's very similar. The enforceability or the finality of that arbitral award is similar to the judgment which is passed by the court. So you can take that arbitral award before any of the courts or any of the proper jurisdiction court, and you can directly enforce it. And the last point is the subject matter expertise. As I told you, so for example, if it's a technical nature of disputes, let's just say today in the evolving nature, AI disputes are very much prevalent. So if you want to choose that actually my arbitrator or the person who would be adjudicating my dispute should have knowledge of AI or cryptocurrency or whatever it is, you can mention it in your arbitration clause, and then only that particular arbitrator will be appointed who has the technical expertise to adjudicate the disputes. Right. Now, coming to the next is that why everyone is running after arbitration in India, particularly. So, as we covered all the advantages, the first one is that it offers a very time enhancing and cost effective process. And another very major point is that arbitration is actually global in nature. So, our Arbitration Act of 1996 is actually derived from a model law, which is the UNCITRAL model law of United Nations. So the UN Unsettled Model Law is uh, what you can call it, a blueprint or a layout which has been adopted by multiple countries. So if I recall correctly, more than 160 countries across the globe have adopted the Unsettled Model Law. So if you see that the Arbitration Act, which is there in India, would be very much similar to the Arbitration Act which you would be having in UK or Singapore or Malaysia, London, Thailand, or Australia, or any of the countries who has adopted this arbitration process. Okay, I think we have a doubt here. Yes, someone has raised their hand.
Sir, basically, I would like to add one more point if you don't mind, can I?
Yes, yes, please.
So, my point is related to the case of the making case law that was recently a decided Parliament case versus Bharat versus Pakistan, and Renu Sagar Limited was the case which I was studying in college. So it was one of the arbitration suit where they were not satisfactory with the foreign, so they have used other and they have with that party of India. India court should decide that what detail in the law. And one of the see that it means we have this thing they the opinion being made by the Bharat as they have stated if the argument is already done in foreign country, then the courts does not have the power to interfere.
Definitely, that is the right position. So whenever the see, uh, it's quite an advanced version of this webinar that you have actually raised that particular topic. So just to answer your question in short, so whenever the arbitration seat is outside India, wherever it is, may it be London, Singapore, or Malaysia, for example, let's just assume an example, right? So let's just say you have your arbitration seat in London. So which law will govern the entire arbitration process?
Sir, I mean the England law or whichever law.
Yes, that is the UK Arbitration Act. So the entire process of the arbitration would be governed by the UK Arbitration Act. Now, adding on to this, for example, you and I had a dispute, right? And you want to invoke arbitration against me. And in our arbitration agreement, it is clearly written that the seat of arbitration shall be London, UK. Now, the next step that you will take after the arising of the dispute is that you will send me a notice of arbitration. If I don't respond to that notice, you will directly approach the courts in London to get an arbitrator appointed. You won't if you are an Indian party and I'm based out of London, you and the seat of arbitration is also London, you won't approach the Indian court. Why? Because the courts where the seat of arbitration is located have the supervisory jurisdiction over the entire arbitration proceeding. So if you want to appoint the arbitrator, you'll have to go to London, the courts before the London. If you want to challenge the award, you have to go before the courts in the London. If you want to apply for interim relief, then also you'll have to go before the courts in London. So everything, every step will be taken before the courts in the London if the seat of arbitration is in London. And the Indian courts would not have the jurisdiction over this. So this is the beauty of arbitration, right? Because once you choose what adding to this thing, another point is that recently, I guess 2 years back, the SIEC, you all might have heard of it, the Singapore International Arbitration Center, it released its report stating that almost 60% of the disputes that are there in the Singapore International Arbitration Center involve Indian parties. So you see, when the parties are actually based out of India, they still go and adjudicate their dispute or they conduct their entire arbitration proceeding in Singapore and they choose the Singapore arbitration seat. Why? Because the Singapore law or the Singapore judiciary is much more effective when it comes to the arbitration. If you must have done some internships or seen some cases, you must have seen that whenever we challenge any award in India, the proceeding goes on for 3, 4, 5 years, or maybe even 8 years in some cases. However, in Singapore, that is not the case. The dispute is adjudicated and decided in a very timely manner. So this provides an edge, and that is the reason the parties choose a foreign seat of arbitration. I hope that answers your query, right?
Okay, sir.
So moving forward, there are primarily two different types of arbitration. First one is the ad hoc arbitration, and the second one is the institutional arbitration. Right. Now, let's just discuss first that what actually is an institutional arbitration. So, does any one of you have any idea what actually institutional arbitration is?
Sir, what is the first one arbitration you said?
Sorry?
Sir, the first one arbitration you said, what is that?
Can you rephrase the question? I think your voice is very feeble or it's breaking in between.
I request all participants to please put up their queries at the end of the section.
It's fine if there are few questions, we can take it in between as well. So that'll make it more interactive. Anyways, so moving forward, the first one is that we have the institutional arbitration, right? So when we say the term institutional arbitration, we mean that the entire process of arbitration is actually being administered by an institution. So if we have multiple institutions in India. First one is that Indian Institute of Arbitration and Mediation, in which I'm currently working. We also have the Delhi International Arbitration Center, that is in Delhi. We have the uh, Mumbai Center of International Arbitration, NCIA. We have the Nani Palkiwala Arbitration Center. So there are multiple arbitration centers in India. So what is the work of actually all these centers? So when I say the term institutional arbitration, I'm referring to all these arbitration centers, right? So when I say the term institutional arbitration, there are primarily four things to add on to this. First one is that every institution has its own set of rules. So, for example, if you see your Arbitration Act, it will simply say that you have to send a notice of arbitration. You have to file your statement of claim. You have to file your statement of defense. Now, if you choose, if in your arbitration clause, if you explicitly state that the arbitration process would be governed by the Indian Institute of Arbitration and Mediation, or if any of the institution you name it, and then that dispute arises, then your entire administrative part of that dispute would be taken up by the IIAM. Now, what the rules offer, what the institutional rules offer, they actually direct your arbitration and make it more streamlined. So, the institutional rule will tell you that in how many days you have to file your notice of arbitration, in which way you have to file it, to whom all you have to serve it, and how the proceedings would be conducted. So all these things are covered by the rules of the institution. The next thing that institution offers is the a large pool of arbitrators. So whenever you open any institution's website, you can check it after the session on the internet. You have a dedicated pool of arbitrators. So what these arbitration institutions do, they maintain a pool of arbitrators. They give the training to these arbitrators and they maintain a very wide pool of arbitrators. So tomorrow, if any dispute arises, whenever the parties come to us for the appointment of arbitrator, then we give them the list of the arbitrators that we have with us impaneled. And from that list, the parties can directly choose whomever they want to appoint as an arbitrator. The next thing is the administrative support. So whenever any notice has to be sent to either of the parties, or any communication has to be made, or the fee has to be collected for that matter, for the arbitrator's fee, or booking of the venue and dispatching of the award. So all these things are communicated through the institution. So all these are the advantages that the institution offers, and every institution has their own fee schedule, as I told you earlier, right? So all these things are the advantages whenever you choose an arbitration institution. Now, second type of arbitration is the ad hoc arbitration. Now, when I say the term ad hoc arbitration, it means that once you choose ad hoc arbitration, simply you will have an arbitrator to resolve your dispute. And now the arbitrator alone will have to manage the sending of notices, the collection of fee, the deciding of venue, and all the procedural formalities that are there. Every communication, every email, everything that has to be done is done by the arbitrator alone. So this is more of a tailor-made process. So if you actually want that this should be there in my process and this should not be there, then you can choose ad hoc arbitration. But it's if you see the global perspective, apart from India, most of the arbitrations that are happening in the world right now are institutional arbitrations. And in India, however, we mostly follow the ad hoc arbitration system. So there's a difference between the two. Now, it's a very simple example if you will see. So, for example, let's just assume that a wedding is being organized, right? So, if you hire an event manager or an event planner, that event planner will take care of everything, right? From food, decoration, and all the things that are involved there, right? So, everything will be managed by the professional or the event manager. However, if you want to do everything on your own, then it will be a big burden to you, right? So if you go with the option one, that is very much similar to the institutional arbitration. And the second option is very much similar to your ad hoc arbitration. So in a very layman's term, this is the broad distinction between the two of them. Yes, we have a doubt here.
Sir, I was willing to ask, like, I have a interest in commercial arbitration and all that. You have mentioned that you are working on the institutional arbitration.
Yes.
Want to know that how the institutional arbitration is different from the litigation, because ultimately we are studying the subject combined in college. So we are not basically differentiating on the basis of the basic litigation.
So that's fine. This thing, I think we can take up this question at the end, right? So once I finish up with the basics, then we'll take up the questions, right? Okay. Now, moving forward, is that how actually institutional rules and act work together. So don't think that the institutional rules and act, these are two something poles apart or something contrary to each other. What the entire purpose or the role of institutional rule, it is to supplement the arbitration act, right? So we have our own center, the presently where I'm working, Indian Institute of Arbitration and Mediation. So we have our own rules, we have our own panel of arbitrators, we have our own training program. So everything is there. You can go and check our website as well. And different services are offered with respect to arbitration, mediation, negotiation. So you can go and check with that. Right. Now, just very briefly, I'll tell you the entire process of arbitration, right from the start till the end. So let's just assume that there are two parties, A and B, right? So there is an arbitration clause within their agreement that in case of any dispute arises, the parties will go for arbitration or the disputes will be resolved through arbitration. Let's just assume that tomorrow A has some grievances with respect to the performance of the contract from B. Now, A sent a legal notice to B, but B did not respond. Now, what is the remedy with A? The next step that A will take is that A will write a notice of arbitration. Now, what is a notice of arbitration? It's very similar to a legal notice, but in that you have to do all the compliances that are given in Section 21 of the Arbitration Act. So, if you see Section 21 of the Arbitration Act, it will give you a rough idea about what all has to be included in the notice of arbitration and how it is to be framed. The most important thing while writing a notice of arbitration is that you have to explicitly make it clear that it is your intention to invoke the arbitration process. This is the foremost important thing, and there is no particular format to it, so you can pick and choose whatever you want. But more or less, it's based on a legal notice only. So the aggrieved party will send a notice to the opposite party, right? Now the opposite party will reply to that notice and the parties will appoint an arbitrator. So both the parties can mutually decide and appoint an arbitrator. They can propose some names among each other and ultimately they can decide an arbitrator mutually. Alternatively, if the parties are not able to agree on the name of any arbitrator, then what they can do is they can approach the courts under Section 11 of the Arbitration Act. This is about the domestic arbitration, I'm telling you, right? So, under Section 11, they can directly approach the court and the court will appoint an arbitrator to resolve the disputes. Now, up till here, your arbitrator has been appointed. Now, once your arbitrator has been appointed, the next process is that your arbitrator will give a written disclosure stating that I'm not related to any of the parties and I do not have any interest in the dispute. Because as you remember, right at the start, at the beginning only, I told you that the arbitrator has to be impartial. he has to be unbiased, because then only he will be able to adjudicate the dispute properly. Once the disclosure has been filed by the arbitrator, then both the parties will file their pleadings, that is the statement of claim, statement of defense, rejoinder. All these things would be filed by both the parties. Then your issues would be framed. So when I say the term issues, for example, say that A has 10 claims against B and B has 5 counterclaims against A. Now the arbitrator will take into consideration these 10 claims and these five claims, and together it will form issues out of it. Issues will be the propositions on which the award would be given. For example, if claim number one, the first issue that is raised by A is that whether the contract has been properly terminated or not, then that would constitute your issue number one. Then the entire award would be given on that issue. So that's how the issues would be framed. Once the issues are framed, then your evidence would be conducted. The parties can lead either cross examination or they can proceed ahead with the document only evidence, whatever they choose. So once the cross examination and everything is completed, then ultimately your award would be passed, right? Once the award is passed, there are again two ways. The party who is aggrieved with the award, they can go and challenge this award before the court under section 34. If they are successful with the challenge, the award will get set aside. Otherwise, the party in whose favor the award is, that party in parallel can take the award and press it for enforcement under section 36. So that's how the broad scheme of the entire arbitration act is, right? So up until this point, does any one of you have any doubt? You can unmute and ask. Okay, there's one query. I think it's more of career oriented in nature. So this we can take at the end. Now I'm going to tell you briefly about how to actually make a roadmap if you want to pursue arbitration in the longer run. Because right now most of you are in the law college only. So I'll tell you some of the things according to that, right? The first thing that the first question that should arise in your mind is that why are the companies actually choosing arbitration? And as I explained you right at the starting itself in the first part of that webinar, that because of the advantages that the arbitration offers, its time effectiveness, cost effectiveness, the confidentiality. So all these things clubbed together, most of the corporate entities that we have are choosing arbitration because no one wants to get stuck into litigation and spend years pursuing the courts. Because comparatively, arbitration gives you the award within the duration of 1 year, right? Next thing that you can cover is that another thing that you need to keep in mind is that what is the prospect of arbitration? Is it actually growing in India or not? So you must have seen for yourself that multiple webinars, conferences, and sessions, everything is being centered around arbitration these days because it is one of the most lucrative fields that a person can choose. Especially why? Because of its international characteristic that we discussed right now. As I told you in the webinar itself, that the arbitration has a international characteristic because it's based on ancestral model law. So the arbitration process or the act, the basic structure of that process or the act that you have in India would be very much similar to the UK, Singapore, or any other jurisdiction within the 160 countries that have adopted the ancestral model law. You can go and check it out. Go and practice there actually as an arbitrator, right? So this is another point which is to be kept in mind. Now, I guess one of the students asked me that how is arbitration actually different from traditional litigation? So see, your litigation process is more or less, you can say, adopted in the process of arbitration also. Because as I explained you, the entire process of arbitration, you have to send a notice of arbitration, then the pleadings are submitted. Because in arbitration, your statement of claim would be submitted. Statement of claim, statement of defense, your rejoinder, all these documents. Similarly, in court also, you'll have to file the petitions, replies, rejoinders, your written submissions, written statements. All these things would also be filed in the court itself. The moment major distinction is with respect to the timeline that it offers. Because in courts, there is no particular fixed timeline that you have to complete the entire dispute within 1 year or 2 years. But in arbitration, you do have that advantage, right? So the entire award is passed in a very time effective manner. That is a major distinction. And also, you can choose the person whomever you want to appoint as an arbitrator. So tomorrow, if you have a dispute related to cryptocurrencies, it's quite possible that the judge would not be well equipped to understand the nuances of the cryptocurrencies or whatever legalities or technicalities are involved in this. But if you take a person who is actually from the AI industry or the cryptocurrency industry, then that dispute can be resolved by that person in a very efficient and a better manner comparatively. And speaking of statistics, in 2025, the ICC published its report. You can go and check it out online, wherein it stated that only in the year 2025, 881 new arbitration cases were registered with them, and the parties belonged to 147 different jurisdictions. And cumulatively, the value of these claims was somewhere around 299 billion US dollars. So you see, all the major, what do you call it, major disputes which are there, which are hefty disputes, which are actually cost-centric disputes, are being resolved through arbitration, because none of the parties can actually bear to lose a lot of time upon the cost which is struck into the dispute. Career prospects of arbitration in government jobs. Okay, I'll take it up towards the end. Just in a few minutes, I'll wrap up everything, and then we can have a proper Q&A session. Right. Now, with respect to the career paths, okay, so one of the person also asked that what are the different prospects or career paths that you can choose. So, what are the different ideas that you have when it comes to arbitration? What do you think, that is it only arbitrator that you can become, or are there some things else as well that you can do within the domain of arbitration? Anyone has any idea?
Sir, can you please repeat the question?
Okay, so when I say the term arbitration, now when we discuss the field of arbitration, what are the different prospects that you can take up, or what are the different job opportunities or career opportunities that you can think of apart from becoming an arbitrator? What do you think is there to offer?
Sir, I guess we can be the kind of expert who have the particular or specialized knowledge about a particular domain. Because
Yes.
one is the arbitrator. Arbitrators how can be the expert in a specialized domain or
Yes, yes, that is the correct answer. Anything else anyone would like to add? Okay. So adding on to this, the first thing is that you can become an expert within the arbitration. So what happens frequently? So for example, if it's a construction dispute, right? And this happens a lot in construction industry, especially. So whenever any retired judge or any person who's appointed as an arbitrator, what the parties do or what the tribunal do, they appoint an expert. The role of the expert, so for example, if it's a infrastructure dispute, an engineer would be appointed as an expert, right? And that engineer would actually go to the site, visit the site, make a proper report that what are the delays, because of what reasons the delay occurred, what is the extension, what is the prolongation. So multiple aspects would be covered by the technical person, and a report would be submitted before the tribunal. Or even this technical person would assist the tribunal in deciding the dispute more effectively, because often you see the infrastructure disputes can be very technical in nature. So to decode those technicalities, the tribunal or the parties, they can appoint an expert witness or an expert person, and that person will actually help the tribunal and the arbitration process to decode those technicalities and help in the assistance of the dispute resolution. So this could be one of the prospects that you can take up, right? Next thing is that definitely you can act as arbitration counsels in arbitration proceedings. So whenever the parties are doing arbitration before the tribunal, you can always have the understanding of arbitration and act as a counsel before the arbitrator uh, in an arbitration proceeding. Next is in many major companies and industries, there are often in-house counsels. Even if you see your NHAI, the National Highway Authority of India, recently it has also released a notification regarding the legal vacancies. So, what would be the role of that person? That person would have to have technical expertise so that that person can assist in the preparation of claims and disputes whenever there is a dispute before the arbitrator or the tribunal. In-house roles can be taken up when you have an expertise into the arbitration, because infrastructure industries often need that thing, right? Next is, which is the dream of many, you can definitely become an arbitrator. But to become an arbitrator, you need to have proper training, years of experience, and you need to have the entire gist of the process. You need to know the entire process of arbitration at the back of your mind, and that will come through the practice. And the more you read, the more you understand and study it. One very important and very lucrative thing is to act as a tribunal secretary. So this thing is not very prevalent in India, I'll say, but internationally it's very prevalent. So when I say the term tribunal secretary, I mean that whenever a person is chosen as a tribunal secretary, so for example, if today there's an arbitration dispute and the arbitrator chooses me as a tribunal secretary, what would be my role? My role would be to prepare the documents, to collect the documents, to streamline the entire arbitration process, to make proper communication with the parties, and to help the arbitrator to decide the dispute. I'll just be an assisting hand to that arbitrator, but the major work would be done by the arbitrator only. So whenever a procedural order would be passed, I can help the arbitrator with that. Whenever any research is required while drafting an arbitral award, I can help the arbitrator with that. If the arbitrator needs any clarification, then I can help the arbitrator. So any research or administrative work that is involved, the arbitrator can choose you as a tribunal secretary. And there's a fee also involved whenever you act as an tribunal secretary. And if you see internationally, in the international realm, it's the Hong Kong Tribunal Secretary course. So the Hong Kong International Arbitration Center also offers a tribunal secretary course. So that also you can go and check it out. So this is also one of the prospects. The third thing would be the institutional case manager. So if you see that the uh, arbitration center that we have in Delhi, that is the DIAC, the High Court Attached Arbitration Center, Delhi International Arbitration Center. So it often comes up with the vacancies for case managers. Now, what is the role of the case manager? They maintain the proper record of the documents. They ensure that all the compliances are being done whenever any record or anything has to be dispatched or any communication is to be made to any of the parties. Then all those things are actually done by the case manager. So this is the broadly career prospects that you can choose. And just adding on to one thing with respect to the domestic aspect of Indian arbitration realm. In fact, DIAC has also published its list of statistical data wherein they have disclosed the number of arbitrations that they have received in the year 2025. And that stands at the figure of 12,115 cases. So in 1 year itself, these many cases have been referred to DIAC for arbitration. And if we talk about the number of hearings, almost 30,000 hearings were held in DIAC in the year 2025 itself. So you see, the field of arbitration is very growing and it has a lot of potential and opportunities, but you need to have a roadmap as to how to proceed. If you're a law student in the initial years, I'll say you can participate in some moots, write articles about it, do some internships that are centered around arbitration, because all these things eventually help you to get the knowledge of arbitration, and then only you'll be able to build up your practice as an arbitration counsel. So this is something very important that you need to have. You can also attend different webinars or training programs, whatever is there, or you can take up certain courses, or but primarily I'll suggest that you can go for internships, because internship is one of the most important thing that you can do to enhance your skill into the field of arbitration. Now, yes, I'm open to all the questions that you have. Yes, someone has raised their hand.
So actually, I want to ask that for litigation, we basically prefer to visit the court and know all the proceedings regarding the court procedure which has been held there.
Hmm.
To be to be an expert or an arbitrator, what all procedure do we need to follow? If you are in a institutions. If further or in future I need to get an institution which is related with commercial arbitration, so what steps do I need to take to be there?
See, what you can do is initially you can build up your CV as I told you earlier. You can write some articles, have some credibility to your CV, have something in your CV to show that you are actually serious about this field and you have some prior experience. Then you can apply for internships into different institutions. You can apply to IIM, you can apply to DIAC. There are multiple institutions that offers internships because simply you can't just go and see an arbitration proceeding because in court you can simply walk into any of the courts and you can actually see what is happening in the court. But as I told you that arbitration is confidential in nature, you cannot simply walk into any arbitration proceeding and see how the process is being conducted. So that is something which you'll be lacking. So for that, you can do internships with some arbitration professionals who are actually working in this field because along with them, you can go and assist and you can actually see how the arbitration is conducted and everything is there. I hope that answers.
Okay, so
Yes, someone else has also raised their hand. You can unmute and ask.
Sir, I have a question that what should be the ideal duration of the course of arbitration, as some institutions are offering 4 weeks course while others are offering 2 years course.
See, it depends on what is your understanding. You need to go through their curriculum. For example, if you are completely new to arbitration, you can definitely not learn anything in 2 weeks or 1 week. You can definitely not. Or even if you know something about arbitration, then it could be considered that you can learn. If you have the understanding of the basics, then maybe you can build up upon it through that course. But if you don't know about anything in the field of arbitration, you cannot simply expect that by doing a 2 week course or 1 week course or simply one or two webinars or some series of webinars, you'll be able to understand the arbitration. Unless you read and learn and do actual work into that field through internships, you cannot learn arbitration simply by reading it.
Sir, I have another question that after bachelor's degree, can I directly do the course of arbitration, or I have to do the LLB course before doing the arbitration course?
See, there are multiple courses and multiple institutions that are offering these courses. Often you can see that even first year students are doing arbitration courses. So there's no bar to this. But ideally, I'll say that you first read about arbitration for yourself, do one or two modes into it, write a research paper, write an article, do an internship, and then decide for yourself whether do you want to build upon this and then further do a course or not. Right?
Yes, sir.
There's another question, I think.
Hello, sir.
Yes.
So my question is regarding the how third-party funding affect the in proceedings in international commercial arbitration.
Okay, so third party funding is a very technical topic, I'll say. And what happens in do you know the process of third party funding?
Sir, I'm just basic reading is done by me, but not actual processes.
So, what is your basic understanding on third party funding?
So party funding is the non-signatory to the arbitration agreement. The third-party funder pays expenses like legal fees, expert witnesses costs, and tribunal expenses.
And
Who is
ultimately, whenever the award comes, a part of that award or certain amount from that award goes to the third party who actually funded that entire arbitration proceedings. So, for
yes, sir.
example, if it's a very cost intensive dispute, for example, it involves a 200,000 crore dispute, and because the fee of the arbitrator, the expert witness, the procedure, the administrative cost, everything has to be paid by the parties. Let's just assume that after spending 2,000 crores, the party went into a dispute and it does not have any more money to actually resolve the dispute or to even pursue the arbitration proceeding, to even to pay the fee of the arbitrator. Then it will take the help of a third party who will fund it. And ultimately, when the award comes, that third party will take an amount from that award. So, speaking in a layman's term, this is the process of the third party funding. It's recognized in India. I think there was a recent judgment as well, in fact, on the third party funding aspect. So this is something you can further read on, but it's not very much prevalent in India, I'll say, but it is being recognized in India.
Could you explain that what is the judgment of that regarding third-party funding?
We can definitely connect after the session. I'll share the copy of the judgment with you and then we can discuss
Sir,
on it. right?
Sir, actually, this is my research topic. If possible,
Uh,
I want
you want
like
me to
it
write your research
is.
paper for it?
Yes, sir.
I'll
I
share the
want some
judgment with
views.
you. Yeah, yeah, I'll definitely give you some inputs about it.
Thank you, sir.
Okay, so are there any more questions?
Sir, if possible, could you please share your any official contact number or email ID so that after the session, if we had any doubt in future, we can contact you.
Sure thing. I'll drop in my email ID with the organizers, and they'll share it with you if that's fine.
Okay, sir.
Okay, we have another doubt. Do we have any further questions, or I think if we can end up with the session?
Sir, may I speak?
Yes, yes, please.
Good evening, sir. So can you please recommend few of the journals where we could publish a research papers and which can be like internationally recognized for applying LLM in abroad countries like foreign countries.
See, personally, there are multiple articles and there are multiple websites and journals on which you can publish your article. One of them is ARAI, and it frequently many Indian students and Indian people publish their article on it. That is American Review of International Arbitration. It is overseen by the Columbia University, if I'm not wrong. So that you can check. Otherwise, I'll say that start from the domestic journals, if I'll say within India itself. Or first of all, start off with the articles. You can publish your articles on Live Law, Bar and Bench, because there you'll get more viewership compared to some random journals if you'll be thinking. So go ahead with Live Law and article for this Bar and Bench first, I'll say. First
And
proceed ahead with that.
for research paper.
For research paper, maybe some NLU journals you can choose, or you can go on the Scopus Index website, and from that you can check what are the journals that are actually have good rating, and on those only you can publish, because that will be more beneficial for you if tomorrow if you want to pursue your LLM or you want to go for your PhD. So based on the ranking of the journals, then you can pick and choose in whatever journal you want to publish.
Okay, sir. Thank you.
Okay, so I think now if everything is completed, can we end with the session?
So we have additional questions to ask, which are put in the chat box. Can you please,
Okay, it's the chat box. Give me a minute.
I may read out for you.
Yes, please.
So, could you please recommend the essential Bayer Acts books, commentaries, landmark judgments, and other resources I should study to develop expertise in arbitration, starting from the basics and progressing to an advanced level?
Can you please give me a just give me a minute? Yes, I think is it fine now? I'm audible. So with respect to books, I think I have a soft copy of few of the books of Gary Bourne and other people. I'll share it with the organizers, and you can share it with the people who have enrolled for the webinar. And with respect to sections, I'll just maintain a list of it and share it with you as well. Because broadly speaking, there are few sections in arbitration which are very much relevant. That is your section 9, 11, 23, 34, 36, 9, 17, 37. Broadly speaking, these are the sections, but I'll also share a book. I have a soft copy of one of the books that I'll share it with you, and you can share it with the participants, right?
We have seen that, sir, do an litigation experience as a
I'm sorry, your voice is breaking in between.
do I need litigation experience to take up arbitration as a career?
Do I need?
to have litigation experience with arbitration career?
No, no, that's not necessary at all. But I'll say do some court internships first because that's how you'll actually know get how to read a file, right? You need to know how to look at a file, which documents to read, which documents to have a glance of, or which documents to skim through. So for that, you can have one or two internships in the courts, and after that, you can have rest of your internships into the arbitration domain itself. But it's not necessary. You can right away start from the arbitration internships as well, or your arbitration experience as well. Do we have more questions?
So I have one more question.
Yes.
So currently I am doing diploma in IPR, and later can I switch to arbitration? Will IPR be beneficial for me in arbitration, or are these two completely separate fields?
I see one more thing I'd like to highlight here very importantly that arbitration can only happen wherein a right in personam is involved. What do you mean by right in rem and personam? So right in rem means whenever a right is available to the world at large. You must have studied in your thoughts or yeah, in your thoughts only. So right in rem is something which is involved with the world at large, which you can enforce against the world at large. And right in personam is that once you enter into a contract with an individual, that's your right in personam because there are certain rights and obligations that you can take up towards the individual. So that is your right in personam, right? So arbitration can only happen for those disputes which are right in personam. Now, most of your IPR disputes, I'll say almost 80% of your IPR disputes are either trademark infringement, copyright infringement, or your theft of intellectual property. So all these things are there. So these are rights in REM. They cannot be taken up into arbitration. The only thing that can be taken up into arbitration is your right in personam. And for that, if you relate it to the IPR disputes, for example, if you have your trademark, you have leased your trademark to any third person or any third company, and then a dispute arises, that thing can be taken up into arbitration, right? Otherwise, blanketly, not the entire IPR disputes can be taken up into arbitration. I hope that answers.
Okay, sir. So according to you, I can like do like IPR plus arbitration.
Yes, definitely. You can have IPR, criminal arbitration, service matters, whatever you want. Depends on
Okay.
your capacity.
All right, sir. Thank you so much for answering. Sure.
Right.
So I want to know the practical aspects in situations how tribunal deal with the commercial interests in settlement decisions.
I'm sorry, can you rephrase your question?
So yes, sir. How should tribunal deal with the situation where a funder's commercial interest may influence the settlement decision?
Where a funder's decision. By funder, do you mean the third party funding?
I yes, sir. Just
Mm,
know more about the procedural aspect.
So, can you tell me a particular situation? Then only I can relate because ultimately arbitration works on the procedure part, right? It's a procedural law, it's not a substantive law. So, if there are some circumstances which actually would hinder or influence the decision, then that thing is not very much appreciated by the tribunal. Otherwise, it's perfectly fine.
Okay. Actually, I don't know the scenario. If you deal some aspect like that, what is your view?
No,
What's your
personally, I
thought?
haven't dealt with any of the third party funding cases because, as I told you previously, this concept is not very prevalent in India.
Okay.
Yes. So, do we have any further questions or can we end it? I've got a lot of thumbs up, so I think we can end it. Over to the organizers now.
Thank you so much for taking the time us today and for sharing your valuable knowledge and insights. It was truly been an enriching and informative session, and we are grateful for your time and contribution. On behalf of the Just Anima, I sincerely thank you for being a part of this webinar and for making this session so insightful for all of us.
Thank you
So,
so much.
So now with your permission, you may now leave the webinar. Thank you once again for joining us and we truly appreciate your valuable time.
Thank you so much. Thank you so much for having me. And it was really an interesting session. All the doubts and the participants. It was also engaging one. So thank you so much. And I'll drop in the soft copy of the study material that I have to the organizers, and they'll share it with you, right? Thank you so much.
Thank you, sir.